The apology for the chair is adopted and seconded. Can we then move to the presentation by the small-scale fisheries out? Okay. I'll first give Mr. Bauer 2 minutes and then hand over to you.
Thank you, Chairperson. Mr. Jooste, the presentations, I'll just give members around the presentations. Mr. Jooste will give us a brief introduction as to the expertise before us on the small-scale fisheries. They will then do a presentation, and thereafter Mr. Jooste will do a presentation, and thereafter the members will then interact for the question and answer session. Can I hand over to Mr. Jooste now?
Yes.
Thank you, Chair. Thank you, Mr. Bauer. Yes, I do not want to take up too much time. I will let our guests take the floor as fast as I can, but I felt I need to contextualize how fortunate we are to have this discussion. During our strategic planning, the committee resolved to review the legislation that is responsible for the challenges that the committee has been briefed on by the Saldanha community in terms of the small-scale fishers. But it is a complex set of legislation plus policy plus regulation that is creating a major challenge with different nuances as you move from north of the Northern Cape around the south coast into the Eastern Cape and KZN. And although the Saldanha Bay community had triggered the review, the committee's review would have to consider a broader challenge than what has been exposed to the committee thus far. And I felt that it is invaluable that the committee is assisted in understanding the run-up to where the policy was supposed to go versus where the policy is now, by being briefed by the group of people in front of you that was very closely responsible for the development of the amended legislation together with the department and also with the development of the policy. So we have people able to interpret the policy and legislation because they were part of the drafting team, not a committee secretariat trying their best also to filter through what is being said and what it means. We actually have the opportunity to engage the people that were part of the development of the policy, which would assist in allowing the committee to understand where the policy was trying to go versus where the fishers find themselves today. And hopefully this will aid the review process. I will leave it there, hand the floor to the Legal Resources Centre. Wilmien, I'm sure you will introduce everybody that you would like to introduce, but the floor is yours. Thank you very much for coming through.
Thank you for that, because we are now going to start on the same par. We were just reminding us, otherwise it's our resolution as the committee. Thank you.
Thank you very much, Chair, and thank you to the committee. We're really delighted to be here and to share the struggles, really, of the small-scale fisheries sector. My name is Wilmien Wicomb. I'm an attorney at the Legal Resources Centre. We're a public interest law firm. We've been representing the small-scale fishing communities since around 2002, and I'll talk a little bit more about what has happened in the last 20 years. My colleague Sadia Kawa is here with me, and then Masifundise Development Trust, we'll hand over to them for the real meat on the bones and of the boring law. Once I've gone through just an overview of legally what has happened in the last 20 years, and then I'll hand over to Carmen. So just to start, and let me just see whether I know how to work my... well, let's wait for my slow computer. But to start, I wanted to give the committee an idea of who the small-scale fisheries communities are. And as actually Mr. Jooste has said, we are talking about communities right around the entire South African coastline, in all the coastal provinces. So these are thousands and thousands of fishers and communities who have depended for generations for food, livelihood, for kind of cultural and social cohesion on access to the ocean. And now I'm just going to start talking because luckily I know what it says. And so before the Constitution, before democracy, these communities were never recognized as small-scale communities and with recognized access to resources. In fact, practically every single one of these small-scale fishing communities were forcibly removed once or even twice under apartheid, right? So it's not that that their rights had ever been recognized, quite the contrary. However, there was less regulation, in a sense, ironically, before the Constitution. And so these communities were all able to find a way to access the ocean, not to the extent that they were supposed to. Of course, that was all reserved for the commercial and recreational sectors. But they were able to access the ocean to survive and to really create a network of survival for their communities. An important aspect also to say is that prior to the Constitution, customary law was not recognized as a source of law in South Africa. Our Constitution, or there was no Constitution, but certainly the legislature and the government of the day did not recognize customary or indigenous law as a source of law at all. It was completely marginalized. And I mention that because this is a critical aspect of the small-scale fisheries sector. Many of the small-scale fishing communities have actual customary or indigenous rights to the ocean. And so now our Constitution recognizes that, and therefore the legislature and the executive must recognize and give proper access to these communities. Yes, I've said those three things. This is the pre-constitutional situation of these small-scale fishing communities. Now, the Constitution, of course, brought a transformation and brought at least the following rights to be recognized. First, the right to equality, which includes equitable access to resources, which includes the ocean, right? It brought this fundamental shift, which is a recognition of customary or indigenous rights and customary law as a source of law equal to statute law. And there was a famous case, the Gongosi case, where specific to fishing rights, the Supreme Court of Appeal said customary fishing rights must be recognized. It can be regulated, but you can't ignore them. You can't just pretend like they don't exist. Then the right to food, and of course, when it comes to children's rights to food, that's not even subject to progressive realization. Children have the immediate right to access food. Right to freedom of trade, to choose what trade one wants to do. And as a whole, the Constitution brought with it this transformative agenda, as we all know. Now, the Marine Living Resources Act of 1998, this was to give effect to the transformation of the fishing industry. Unfortunately, the way that transformation was envisioned was to keep this sector very much as is, so only three categories of fishers to be recognized: commercial, the big large-scale industry; recreational, sports fishers; and then a category of subsistence, which was really just fishers who were only allowed to fish to eat, but not even sell at a local level. So that was very, very much only subsistence. And so the transformation was supposed to happen through transformation of the ownership of industry, not transformation in the sense of opening access to local communities. Another thing that happened shortly after 1998 is that a slew of marine protected areas were declared right around our coastline. And these marine protected areas, that was all done in 2000, and they were almost all of them in small-scale areas, so areas where small-scale communities were fishing. And the reason this happened probably is because the small-scale communities were never properly recognized, so no one even realized that their traditional grounds were targeted. And so suddenly, with the stroke of a pen, many of these communities lost total access to their livelihood, or it became very difficult with arrests and such in these marine protected areas. Then I've talked about the transformation of ownership of the industry. And importantly, there was no attempt of restitution, right? So we have restitution of land rights, but the fishing rights, the ocean rights that were dispossessed of these communities, there was no mechanism for restitution. And so the small-scale fishing communities fell literally through the cracks. They were not commercial, as in large-scale, big boats, had all the kind of financing that was necessary to fish offshore, so they largely couldn't apply for commercial permits. They were not subsistence. Yes, they fish to feed themselves and their families and their communities, but they also sell. They sell locally and even to marketers, but at a much more local level. And so they also couldn't be subsistence, because then most of their livelihood would be unlawful. And of course, they were not supposed to be recreational, because that's sports fishers, but many of them ended up being forced to buy post office permits just to survive through these recreational permits. So this wholly untenable situation came to the attention of, in fact, the Human Rights Commission first, Masifundise, and then they approached the Legal Resources Centre way back, who then went to the Equality Court and challenged the Marine Living Resources Act on behalf of the small-scale fishing communities and said, this piece of legislation is in fact discriminatory. It does not allow for small-scale communities to realize their right to food, their right to equitable access to the resource, their right to culture, because it is in so many instances an integral part of the culture of the communities. And the minister at the time, so this was the matter went to court in 2004. In 2007, a settlement was reached, an order by agreement was taken, and the order said that the department had to create a small-scale fisheries sector, had to ensure that the socio-economic rights of the sector is realized, and that there would be equitable access to the ocean. So that is what the order said. It was envisioned at the time that it will only take a year or so. Of course, it took many years. There was a very, very good process where a small-scale fisheries policy was developed, very inclusive, and that policy was then adopted in 2012. So finally, there was recognition of the small-scale fisheries sector. Now, the key principles of this policy and of the sector, these I want to highlight because they are really important. So the first really important principle was that the communities fought for a community-based right. So they said, different to commercial fishers and even recreational subsistence at the time, it's a community of fishers. Yes, we go to sea individually also, but the women in the community, they flag the snook. Other people in the community, they fix the nets. They're all part of an economy of a small-scale community. And so if you're only going to give individual permits to individuals, that takes away the livelihood of the community, which is something that's always been integral. What's also important was the community said, we know the ocean, and so we know how to regulate access between us. And so if you give it to us one by one, then we don't have a means of regulating in the community who goes to sea when. And so this was recognized as that the right would be community-based. There would be preferential access for the small-scale sector. This is very important. So, the department would ensure that the small-scale sector has sufficient access. And I should say that South Africa is actually an outlier on the continent, because in most of Africa, in African countries on the coast, there are exclusive zones for small-scale communities inshore. And those zones are then for the exclusive access and use of small-scale fishers. And so preferential access, it was the idea that you have zones for small-scale fishers where you ensure that they have access to the resources that they require to be viable, right? Then another very important principle was this idea of a basket of species. So with commercial fishers, a commercial fisher applies for one species at a time. And so you get a permit just for rock lobster, or you get a permit for lionfish. But small-scale communities, they fish a variety of species because they fish all year, and they need to fish for whatever is available at whatever time of the year. And so the idea was that they were not going to be awarded one a species at a time, but a basket of species, and the department was going to look at the different areas, at the needs of the different communities, and award them a basket with different species in there, so that they could, again, as a community, regulate how to make that viable. And finally, the principle of co-management. And again, this was the idea that the community at the local level understands the resource and how to regulate it much better than people sitting in Pretoria, and therefore they will play a very significant role in how the resource is managed at a local level. This is also in line with international practice. So this was the policy. Now the legislation, the Marine Living Resources Act, had to be amended so that the Act allowed the minister to implement the policy. So, of course, at the time, this was 2014, we told the department to properly implement this new small-scale sector, you're going to have to make quite dramatic changes, because this sector operates completely differently to commercial and recreational, where you have a system of individuals applying for individual species, and they're individually allocated for long-term rights, etc. The department acknowledged it at the time, but they were in a hurry to get an amendment through. And so the idea was, let's just put in minimal amendment to the Act, and then we'll do a proper full review as soon as we're able to kick off this sector. Unfortunately, the minimal review is still what we have today. There was never a proper full review of the Marine Living Resources Act. And we will see that the implication of that is that the sector has remained a little bit of an add-on. So you have the mainstream commercials. The recreationals, I can tell you, they are pretty much left to their own devices, completely unregulated, and there's an enormous recreational sector in South Africa. Regulation and allocation focused on the commercial sector, business as usual, and then whatever is left over, the crumbs, are going to the small-scale sector. This was never the intention, and so this is a critical issue that needs to be addressed. Then, in terms of the legislation, regulations were promulgated, and unfortunately, these regulations really were not consistent with the policy. So the regulations really just tried to tack on the small-scale sector to the commercial and recreational allocations. So, for example, it now says fishers must choose between commercial species and own-use species, and if you have a species for own use, it means you can eat it, but you can't sell it. If it's for commercial use, you can sell it, but you're not allowed to eat it, not even if you can't sell the fish. You're not allowed to eat it. This is not how things operate in these small-scale communities. It's completely out of sync with the reality on the ground, and it has really been to the detriment of these communities. And then what's really important is that even in the legislation, the minister was enjoined to create small-scale fishing areas in consultation with these communities. That has never happened. That has not happened, and the basket of species has also not happened. So finally, we've seen the problems in the Act, then the regulations made it worse, and unfortunately even the implementation has made it even worse. And so, as I say, the small-scale fishing areas and basket of species, that was never done. There's no co-management anywhere implemented. The recognition of customary or indigenous rights, there's only been lip service to it. It's never been implemented properly. There are thousands of customary fishers who are still not recognized. And there was really no paradigm shift, like the way you had to create a new mechanism for small-scale fishers, and as a result, they are literally left with the crumbs of what is left over by the commercial sector and the recreationals. And we are so grateful for the opportunity to bring this issue to your attention, because it is really significant. I'm going to hand over to my colleagues at Masifundise now. Thank you.
Good morning. Good morning, Chair. Good morning to all the present. My name is Carmen Mandarino. I am the Program Manager and Acting Co-Director